the court. My name is Diana, and I'm the pretrial attorney for the prosecution in People v. Fromholz. The prosecution requests that Exhibit A be entered into evidence in the trial. The totality of circumstances available to Detective Sachs indicated that Alden Mitchell had authority to consent to the search of defendant Fromholz's laptop. There are two kinds of third-party authority: actual authority and apparent authority. Apparent authority can be enhanced by the totality of circumstances, which are all the facts available to searching officers at the time of the search. If neither authority is present, then there is no authority for a third party to give consent to a search, as seen in Trial v. Freed, 275, Fed 3rd at 391. I will be giving the court a brief explanation of actual authority. Due to time constraints, I will be focusing on apparent authority and the totality of circumstances that validated Mitchell's authority. Actual authority is present when a third party, such as Mitchell, possesses common authority over the place or item to be searched, such as...
How does Mitchell have any actual authority?
Your Honor, consenting party Alden Mitchell and defendant Fromholz were co-inhabitants of the shared hotel room suite during the time of their presence on Recipe for Success. Do I have to add in that part?
You can.
Okay. Whenever two parties have common authority over an area, as defined in United States v. Matlock, courts find that both parties have assumed that the other party, can I read this really quick? Okay. Can you re-ask the questions?
Sure. How does Mitchell have any actual authority in this case?
Consenting party Mitchell and defendant Fromholz have common authority over the common area within the shared hotel suite. Common authority is defined as the mutual use of a space or property by a person or persons generally having joint access to the space or property for most purposes. And in this case, it's reasonable to say that Alden Mitchell had common authority over the common area within the shared hotel suite because Mitchell had a key to the hotel suite and was able to bring anybody he wanted into the common area within the shared hotel suite.
The opposing counsel makes a point of saying that the laptop at issue in this case was in a closed room belonging to the defendant. How does that factor into actual authority in this case?
Your Honor, I would like to point out that Mitchell's actual authority evaporates at the threshold to defendant Fromholz's bedroom, where from then on Mitchell possesses apparent authority. And it has already been established in United States v. Andrews that whether a defendant's bedroom door is closed or open the fact that a defendant's bedroom door is closed or open does not affect a third party's authority to consent to the search of that bedroom. I would also like to point out that although defendant Fromholz's door was closed, it was unlocked, which indicated that defendant Fromholz did not have a high expectation of privacy for the contents within defendant Fromholz's room.
Thank you.
May I continue?
Please.
Okay. Actual authority. In the case of United States v. Kimawana, the court considered the facts available to searching officers at the time of the search to be sufficient to commence a search without a search warrant. Officers were aware that Nick carried a key to the hotel room, had spent the night in the hotel room, and had left possessions in the hotel room, all of which signaled third-party common authority and thus actual authority to consent to the search of the shared hotel room. Apparent authority is present under three elements. 1. Visual indicators of third-party authority to consent, such as the mutual use of a space or particular container. 2. Whether officers were told incomplete or untrue information. And 3. The fact that when faced with an ambiguity, officers acted with reasonable caution and further inquired about consenting parties' right to search, about the third party's authority to consent to a search. As seen in United States v. Andrews, 483, Fed 3rd at 711. During Detective Sachs' search, all three elements were present. In our case, Mitchell's actual authority evaporated at the door to the defendant's room, where no common authority existed. From then on, Mitchell had apparent authority, which extends to entering the defendant's room, opening the defendant's computer, powering it on, displaying the defendant's desktop user account on the screen, and included the logging in process, because nothing in the facts indicate that Sachs knew or should have known that the defendant's laptop password had been changed. In United States v. Buckner, 473, Fed 3rd at 551, the court concluded that Michelle, the defendant's wife and co-inhabitant, possessed apparent authority. The totality of circumstances provided officers with the basis for an objectively reasonable belief that Michelle had authority to consent to a search of the defendant's computer hard drive.
How is it what is the significance of the fact that, Mr. Mitchell apparently, was able to come into possession of this password without, the defendant actually giving him the password? How is that significant in your analysis in this case?
Your Honor, the appellate court held that in United States versus Buckner, there are 3 elements that go under apparent authority. One of those elements being whether officers were told incomplete or untrue information. The fact that Alden Mitchell had, as opposing counsel states, dubiously acquired defendant Fromholz's password goes under the incomplete information category, as Detective Sachs was unaware of this information at the time of Detective Sachs' search.
Thank you.
May I continue?
Yes.
Thank you. There are significant similarities between the facts of People v. Fromholz and United States v. Buckner. While the 2 cases are not identical, the similarities are significant. A. In both cases, each third party told searching officers that they occasionally used the defendant's computers to play games. B. In Fromholz, Mitchell told Sachs that Mitchell could get into the defendant's computer. In Buckner, officers observed that the computer was turned on with its screen contents in plain view.
1 minute.
In Fromholz, Mitchell did not tell Sachs that the defendant had changed the computer password. In Buckner, Michelle was unaware of password protection. D. In Fromholz, Sachs took a picture of the defendant's desktop screen, but did not open files. In Buckner, the officers made a copy of the defendant's hard drive, but did not open files. Detective Sachs is taking a photograph of the defendant's desktop is analogous to making a copy of the computer hard drive, as searching officers were simply saving information for later review. E. In both cases, the defendants believed that they
30
were the
seconds.
only people who knew the password necessary to sign into the computer and view the password-protected files that they had created. The totality of circumstances in both cases warranted searching officers of reasonable caution to believe that consenting parties had authority. Your Honor, the prosecution requests that you deny the defense's motion to suppress. The totality of circumstances support Mitchell's apparent authority to consent to the search of defendant Fromholz's computer. There was no violation of the defendant's Fourth Amendment rights. Thank you, Your Honor.